great event. You guys are going to hear a lot of great information. Very much. I'm going to hand it off to Dean Stanley now, and enjoy.
Thanks. I've never started so much on time before. Thanks, Travis. Really glad to be here today to welcome you all here. As he said, I'm Associate Dean Kim Stanley. I'm also a tax professor, and wanted to highlight some of the great things we're doing at the law school in connection with our business law curriculum, and also clue you in on some of the new trends in business and corporate law lawyering. So we've invited 5 very, very distinguished adjunct professors here who are going to talk a little bit about their areas of practice, and also tell you a little bit about the courses that they teach, and then have lots of time for your questions and any questions you might want to ask. Like, now's the time to ask, is like, well, what does it pay to work at? No, I'm just kidding. For our panelists, we have first and second and a handful of third-year students here, right? Mostly first and second-year students. And members of the Business Law Society, as Business Law Association as well. So, without further ado, let me briefly identify and welcome our panelists and tell you a little bit about each of them. And then ask each of them to speak for a few minutes and tell you a little bit about what they do in their practice and what their pathway to get there was, what they took in law school, what prepared them for their practice, and then sort of the new things that are happening in business law, business and corporate law. So we'll start right in the middle of the table with Paul Chen. Paul is a partner at DLA Piper. He is officed across the street here in San Francisco, but has a very, very vibrant cross-border practice and travels a great deal, particularly in Asia. So Paul is part of the group at DLA Piper who handles mergers and acquisitions. And his practice is domestic and international clients, investments, divestitures, and other corporate transactions. Seated next to him is Spencer Marshall, who is an associate who works with him also at DLA Piper. Spencer has been with DLA about 3 years. Comes out of the LM program at Georgetown Law School in tax, I'm assuming?
No, it's securities.
Oh, come on, no. And works with Paul as well. And I'm thankful to our recent grad, Jamil Clintock, who is also working with Paul and Spencer, and introduced him. Appreciate that. To the right, your left of Paul is Jessica Blazer. Jessica is currently an adjunct teacher here, teaching our cyber law and privacy course. She's teaching that this semester, and she will be teaching it next semester as well. She's formerly the senior privacy counsel at Chevron Corporation. And prior to that, she worked at Wyatt Corporation, also as privacy counsel. She went to Benjamin Cardozo School of Law and has been working in the area of privacy law for about 15 years. I did mention that Paul and Spencer will be co-teaching the mergers and acquisitions course in the fall. To Jessica's right, your left, is Amy Barnard-Vaughn. Amy is the senior corporate compliance and ethics counsel at McKesson Pharmaceuticals. McKesson has their headquarters a few blocks away here in downtown San Francisco. Amy has for about 20 years been a leader in the nationwide movement for corporate compliance and ethics professionals, and will be teaching a new course in our schedule next fall on corporate compliance and ethics. Fascinating area of law, growing, emerging area in which there are new jobs becoming available. I'll let Amy explain it more, but I regard it as sort of like, who does keep her CEOs out of jail? In a nutshell, that's what she does. And then finally, at the far end of the table is Tony Barnes. Tony is a senior attorney at Cooley. law firm, major law firm, and he is chairs their e-discovery department. E-discovery has to do with discovery of electronic records in litigation and also records management. Obviously, there's a huge bulk of information that we have available on computer systems. That is an aspect of lawyers' work, all the time. There are lots of jobs emerging in the area of e-discovery. So those are our panelists. Let's start with them. Very much appreciate having them here, and I think we'll just start with maybe Paul.
Sure.
And we'll just start with you. If you have questions, please feel free to ask them along the way.
Well, first of all, thanks for having me, Dean Stanley. This is a great audience here, great turnout. So, I think I remember sort of being in the audience myself. It was a long time ago, but I still vaguely remember. Would like to be a student, and I think this is a really exciting time for you guys. Getting a law degree is empowering in a lot of ways. I see some people snickering. I mean, you'll realize, what you have right now a few years later. But getting a law degree is extremely empowering, and you can do a lot of things with it. So I've been asked to talk a little bit about my career and what I've been doing, what I do now. So I use my law degree for a couple of things. One, obviously, is to practice law at a law firm. But I was a management consultant for about 3 years, and I did business development at a tech company in Asia for a couple years as well. So, your law degree, you don't need to get a joint MBA or whatever either. Your law degree can propel you to do many different things because you're going to get a background in a lot of different issues. So, so my career path was that I started off in New York. I went to NYU for law school, and so naturally I sort of stayed in the city. And practiced there for a little while before actually going out to Asia to practice. So I did corporate M&A, and at that time there were a lot of IPOs going on for technology companies in Asia coming to the United States. So I did a lot of that, and did that for a few years with a law firm called Skadden Arps. And then I went to McKinsey & Company as a management consultant for a couple years, where I advised various companies in a lot of different industries in strategy. A lot of it had to do with their M&A strategy. But that's where my law experience actually helped me, because I knew how to get deals done. That's what lawyers do. Right now you're learning the theoretical aspects of the law, which is good, but once you actually start work, it's completely different in a lot of ways. I mean, that theoretical background, that logical thinking, analytical thinking that you're getting right now is really helpful, but once you're actually in the practice, and Spencer can probably talk about it a lot more than I can, but things really become quite different, and your approach to the law actually has to be very different as well. But it becomes one where I think you're going to focus on your practical skills, common sense, and finding smart solutions for your clients. At the same time, you're really, at least for M&A and corporate transactions, you're always plowing forward and getting something done, and that actually prepares you for a lot of different kind of jobs out there. Whether it's to eventually become a partner at a law firm, counsel in-house at a company, or a business position. Because all those types of work traits are valued by companies to basically get things done and done in a very efficient and detailed way. So after my sort of business roles, I decided really after 9/11 to go back and to my home market, which is New York, and really just kind of put my head down and just did corporate M&A transactions for probably 6 or 7, 8 years in the New York market. And really fun times. At that time, the market was really booming. Law firms were really doing well. I mean, it's a more challenging environment now. We can talk about that later. But at that time, it was a really great training ground. Doing really large transactions and being really busy. So that generation of lawyers that was on the corporate side, we're actually really fortunate because they got this experience. Now we're hoping that those days will come back, but realistically, I think it's probably going to take a little bit of time, and I think the legal profession's changed a bit. But that doesn't mean you're still not going to, you're still going to be able to have opportunities to get some really good experience out there. And so, to make a long story short, because I want to do some for other people, obviously, is then I did a management role for another international law firm out in Asia, and then came back to California to sort of interact between Asia and U.S. So, I can talk about that more offline, or if the opportunity permits here at this panel.
Great, so just to clarify, I introduced you as an M&A lawyer. Can you give us a sense of what that means?
Yeah, I mean, basically you're representing usually a buyer or a seller of a company or of assets of a company. Or in public deals, you may actually end up representing like a special committee, like in a going private deal, for example, where there's some conflicts of interest, where the management's buying out the shares of a company, then it's required under fiduciary duty law and also SEC rules to have a special committee. So then you can actually end up representing a special committee to determine whether the value that's being paid on the deal is actually fair and from a legal perspective. So M&A basically entails parties negotiating a contract, and that contract usually contains a lot of ancillary documents to capture the business understanding between two or more parties. It's a dynamic process. In public deals, it's probably more formulaic in some ways because there's only so much information out there and you have to disclose everything. But in private deals, which Spencer and I actually work on more, I would say that there's a lot of flexibility and more creativity out there. And you really look at the negotiation leverage that your client has to get the best deal terms. It's a lot of fun because you get to negotiate contracts and you don't know where you're going to end up.
Great. Maybe let's move to Amy. And again, just give us sort of a brief highlight of what you do in your job, how you got here, and maybe what opportunities there are for emerging lawyers.
Great, happy to do that. I think of what I do as helping companies and people do the right thing. So I started off with a very strong public interest background actually, and would have never guessed that I would want to work for a Fortune 14 huge company. But so I think of what I do as kind of public interest for corporations, if you will, helping keep people out of trouble. And I love my job because I feel like I'm empowered to do the right thing. If I feel like an employee is being disadvantaged in a situation, I feel like I can do something about it, and I'm uniquely positioned to do that. And also that also, of course, keeps the company out of trouble. And then if an employee is taking advantage of the company, if they're stealing or doing inappropriate things, I can take action as well to protect the company. So it's a really multifaceted job. I would have never known that I would have ended up here. I've really had 3 different careers. I started out as an employment litigator. Then I went into HR for about 8 years and then transitioned back into the law department at a financial services company, Fireman's Fund, where I worked for 11 years before joining McKesson. And all of that experience really built on itself and lends itself to a very good background for what I do, which is building a corporate culture that encourages compliance and commitment to the law and to ethics. I like it because it's a tall order. You can imagine that sounds pretty broad, and it is. At every company, it's different. You have to look at the risk profile, the types of businesses that you're in. The things I've done at McKesson over the last 4 years are build a team from scratch to handle our 5 biggest risk areas, which are data privacy, government contracting, healthcare fraud and abuse, records management, which I have, so e-discovery is a big topic for us as well, and anti-corruption, because I have about 15 different businesses. One of them is a generics outsourced manufacturing business in Ireland. So we contract for drugs in India and China, so we have an interest in making sure there's no corruption in their transactions there. It's an amazing and booming career field. There's not enough people out there that are qualified for the job right now. The reason I'm actually sitting here is I happened to meet Dean Rachel and was just saying, hey, I've had this job for 11 months. Are you guys teaching me stuff in law school? Because I know it wasn't taught when I was at Georgetown. And I've learned on the job, and I just kind of fell into this and loved it. I got lucky, but just no. And then one thing kind of led to another, because I had an open role, a director role, a very good role, over 6-figure salary, open for 11 months. Couldn't find anybody for it. And then 2 months ago, there was a great article on the cover of the Wall Street Journal about compliance and how it's booming and how it's just really not going to go away. I mean, increased regulatory enforcement, and then just loss of investor and public confidence in companies after Enron and after Walmart and just all kinds of things. Sure, there's no lack of going to the news. So in the course, we'll be covering 7 elements of effective compliance program. It should be a lot of fun, whether you're going into a corporate environment and want to work for a company, or whether you want to work for a law firm. You will be better positioned to advise your clients, because often you will run into a mess. And if you know about corporate compliance programs and best practices, then you can advise them that, hey, if they want to prevent this kind of thing from happening again, they might want to invest in a corporate compliance infrastructure in their corporation. Also, if you want to be a prosecutor, government's making a lot of money right now prosecuting corporations, particularly for data privacy and for anti-corruption. It's just a huge moneymaker. So I'll stop there, but probably an overview.
Great. Well, why don't we move from there on to Tony at the end of the table about, he teaches e-discovery and works in e-discovery. Tell us a little bit about, like, a lot of people don't even know what that is.
Yeah, we'll get to that. I started my career as a litigator. I've been a lawyer, practicing lawyer for about 16 years, and my career has been split 8 years as a litigator and 8 years as an e-discovery attorney. I started my career at Roper's Majeski here in the Bay Area, a medium-sized small law firm handling medium-sized cases, nothing like I see today in the e-discovery realm. And then I moved to Burnham Brown in Oakland with 2 partners after a few years at Roper's Majeski. After law school, I had taken both the New York State Bar exam and the California Bar exam. So after 2.5 more years of litigating at Roper's, I made a move to New York to work for a loosely associated law firm in New York City. Again, doing litigation, medium-sized cases on the defense side, taking a lot of depositions, going to court a lot. You have a big caseload with those firms, not 2, 3, 4 cases, more like 30, all at different stages. So it's really a lot of project management in a lot of ways. It's hard to get trial experience in general as a litigator, as a young litigator. So my brilliant plan was to leave that job and start working with all the plaintiffs' lawyers I knew in Kings County and Brooklyn and Manhattan and Queens, which was great, but it didn't particularly pay very well. And a few months into that, working sort of per diem and handling other deals, getting some trial work that I had desired, my wife got pregnant, so I needed more consistent money, and I knew a lot of people in the staffing industry through my work in New York as a lawyer and through general other connections. So I started managing large document reviews, and that was really sort of this burgeoning thing where technology wasn't quite where it is today, but then again, competing against that, there wasn't as much data. But nevertheless, big cases, corporation on corporation or class action cases, just to name a couple of examples. Within those cases, you need to go collect data that is potentially relevant from your clients, and you need to counsel them as to how best to do that, to make sure they're getting everything from the what we term key players, those thought to hold potentially relevant information. And then once you get that data, it's not cold, it hasn't really been sorted in any way. So that is when data vendors come in, and to shorten this up a little bit, you end up processing that data, running search terms over it. Today the technology is advanced there a little bit as well. And eventually you get it into a relational database, a review database where you can march through the documents and make coding decisions relevant or non-relevant. So I started managing those projects. Shortly thereafter, I got word that Wilkie Farr was starting an e-discovery department. This was really early in this whole industry in a lot of ways. Law firms were reacting by hiring people to sort of handle these things because the associates hadn't had quite the amount of experience, and they were busy doing other things, and you needed more people to handle it. So I got the job at Wilkie Farr as an e-discovery staff attorney. And we really, there with a partner and who eventually handed it off to special counsel, developed this entire department with protocols and workflows and making sure, risk management is sort of paramount, and making sure that all of our ducks were in a row. After 3.5 years at Wilkie Farr, my wife and I, we now had 3 children, and we decided to move back to the Bay Area. This will sound a little bit crazy for cost of living reasons. Literally significantly cheaper where I live now to get a house with a backyard. So that was our brilliant plan, and it worked out to in some extent. At that point, I started working for a large data vendor, really a consulting firm that does electronic discovery. Data vendor, very, very high-end shop, FTI Consulting. And there I worked on one of the, to my knowledge, largest cases, e-discovery cases to come down the pike recently, involving internal investigations, regulatory investigations in 3 countries, and a slew of individual cases, a slew of securities cases. It was a massive project management endeavor. And I worked at FTI for about a year and was then offered a job at Cooley as a senior manager e-discovery attorney. And I've been at Cooley for about 2.5 years. Cooley's department was a little bit more developed, certainly than when we started at Wilkie Farr. So we've been able to change things, and the industry's changed a little bit. A lot of firms are sort of outsourcing this and outsourcing that, trying to get into managed services agreements with data vendors so that you've got a volume, a certain data volume that you can host for your clients at a capped price. A lot of it now is budgetary, how best to serve your clients on a tight budget while not cutting yourself out of the loop. You've got to make it work for the law firm and make it work for all the clients. So there's a little bit of a delicate dance that goes on into how you set up your contracts and how you serve your clients in that end. Part of my practice today is to counsel with respect to all the case law. I'm moving a little bit away from the day-to-day project management of these large e-discovery projects and getting more into I've always been doing a lot of the e-discovery case law counseling. Lawyers don't typically focus on what the e-discovery law is, what your requirements are, what the discovery rules say, what the FRCP says today after the amendments, and they're about to be amended again to sort of deal with the big data issues that clients are suffering today. Because the more data you have, the more likely that more of it is likely to be potentially relevant. So accordingly, the more you have to take in, and that just downstream costs escalate sort of on a per gigabyte basis, not to get too technical. The course I teach here straddles the line between very technical and e-discovery law. We handle all of the e-discovery law from start to finish, and it's kind of a chronological march. So you sort of starting with preservation analysis to the client when they are served a suit or have a subpoena, or anytime they foresee litigation, they need to preserve that data. So there's law on that, and then there's law on the best way to ensure that you're collecting data from the proper people, and then you move on through to processing and document review and finally production. All through that timeline, there's law to be taught. A couple of things we've done is we've had a project manager in the e-discovery realm, a lawyer, come in and do a guest lecture. We did a guest lecture on forensics. It's a big part of e-discovery. Forensic imaging of computers, making sure that when you pull data down, that it's not altered in any way from the client, and vendors typically handle that as well. So that's really what the course is about. As far as opportunities, not to belabor going too long here, but as far as opportunities, there's a ton of opportunities both in-house, in law firms, and for these data vendors, and you see lawyers manning many of them. The forensics jobs are typically handled by computer science folks, experts in that arena. But lawyers do a lot of the project management on the data vendor side. They are obviously welcome in law firms as e-discovery attorneys. And a lot of what you do on that realm is to train young associates and to make sure that they're learning, because you don't have the bandwidth necessarily to handle every case that comes in. You need to train people and be there for sanity checks when they call you. Google, for instance, as far as in-house goes, they've got probably what amounts to a 100-person e-discovery team internally. And if you think about it, you might see why. And then the vendors, there's sales, business development for the data vendors, people that want to come in, help you collect the data, and then host it for you offsite so that the document review can be handled through a web-based relational database, so you can review from any number of locations. There's also, the last thing I'll mention is contract attorney agencies. A lot of the people that work there are JDs as well, and that's more of a business development role. Although contract attorney agencies now have project managers as well, and they primarily just manage these large document review projects. Not all of them are all that large. Some of them only require 5 lawyers and last 2 or 3 weeks. I'll leave it there.
Let's jump to Jessica and tell us a little bit about what a privacy lawyer does, and then we'll finish up with our more junior member of the panel, Spencer. And Spencer, I was thinking, I'd be very interested in when you, if you could talk about the learning curve from law school to practice. Go ahead, Jessica.
Great, thank you. I'm Jessica Blazer. I currently teach privacy and cyber law. This is the first semester being offered. I plan to teach it again in the fall. And then in the spring, I think the idea is to create and teach another privacy course. You've heard so far everyone talk about their various areas. Privacy touches everything these days. Often part of a compliance or ethics office within a company. Most law firms have privacy offices these days. Many firms are creating privacy practices. They can be one attorney who specializes. It can be a multi-person group. Certainly it touches M&A, it touches e-discovery. I'll talk a little bit about all of that. And we've talked about most of those topics in class as well. My career, actually similar to Amy, I started in litigation. I had a very strong public interest background. Had the opportunity to become a healthcare attorney doing regulatory and transactional work, and was doing this in the late 1990s, back in the 1900s, when the first HIPAA privacy rule came out. And so happened to be in the right place at the right time and broke my teeth on privacy, following the rule in its many iterations, understanding the commentary, understanding the legislative history, and then interpreting, speaking on, writing about, advising my clients as part of a healthcare practice on how the HIPAA rule impacted what they were doing. Did that for a number of years in a New York law firm, and actually similar to Paul, right after 9/11 left New York. Decided I'd spent long enough in a law firm, was long enough in New York, and went in-house. I've been in-house since 2001. I stayed within the healthcare industry for about the first 7 years of my practice. At the beginning doing regulatory and transactional, including privacy work, and then moving to a strictly privacy role in an international pharmaceutical company. About 6 years ago now, I came out to the Bay Area. I was Chevron's privacy counsel, Fortune 3 company. One privacy counsel for the entire company. Operates in over 100 countries in the world, thousands of entities and affiliates. When I started at Chevron in 2008, there were a couple of dozen countries where we operated that had privacy laws. I left by choice in August of last year to take a bit of a sabbatical and rethink, take a step back, breathe a little bit. Fortunately, being an in-house attorney, and Amy can talk to this too, affords a certain lifestyle and allowed me the opportunity to take some time off, so I did that. And I love privacy law. I'm looking to go back into it. considering a number of opportunities, trying to figure out if I'd like to be an in-house consultant for a law firm for their M&A work, for example. When companies take one another over, there are all kinds of privacy issues with respect to their customer lists and their employees and their shareholders, their boards of director, working with litigation and e-discovery. Tony was talking about the size of some of these e-discovery efforts. Guess what? If personal data is involved, there are privacy issues. Working in-house again in a compliance or ethics office. Things like employee privacy, things like internal investigations. If you're investigating employee wrongdoing or accusations of wrongdoing, there are privacy issues. It's pretty ubiquitous. If you open the newspaper, NSA and Edward Snowden, guess what? That's privacy. Google Glass is coming out. There are all kinds of issues with privacy because you might not know what people are looking at and recording and posting online. Social media. The more ubiquitous technology gets in our life, the more ubiquitous the privacy issues are. So I love it. It's a burgeoning field. You can find privacy jobs in a number of arenas. Government, I'm seeing more and more postings for government agencies looking for chief privacy officers or privacy counsel. In-house companies are looking for all kinds of privacy folks. Amy mentioned positions have been open for 11 months or more because there aren't enough of us who have that depth of knowledge or experience. Law firms are starting practices or expanding their practices, hiring in-house consultants for some of their work, even without specializing or offering the work to their clients. So there are plenty of opportunities. I find it to be fascinating. I see a few folks from my class, and I thank you for being here. But they can tell you I brought in a number of outside speakers. There are a good number, especially here in the Bay Area, with tech companies, healthcare companies, financial companies, but especially the tech in this area. A lot of folks who have been doing this area of law for 15 or 20 years, like I have, who knew the area before there were organizations that helped privacy professionals get their CLE or get certified in privacy. And they're doing fascinating work in all kinds of companies out here. We talk about a range of issues. We get more in depth with some than others, and I'm hoping to continue that and offer some real deep dives into some of those areas impacted by privacy.
So I'll just give a brief background. So out of law school, I started clerking for a federal judge and decided halfway into my clerkship that it wasn't something that I really liked to do. And beforehand, I wasn't really, into litigation, but it was a cool opportunity. But beforehand, I had worked for Goldman Sachs in the city doing credit default swaps up until 2008. When that was part of the reason for the financial crisis. And then after I would say, then I went back to city for a little bit, and then I went to FINRA and SEC, where I was part of a special commission to prosecute some of my former colleagues. So I had an interesting background, and all of a sudden one day, and it was kind of out of the blue, I decided, you know what, I really want to kind of switch gears. I was a derivatives expert, and I wanted to go into M&A and do some venture capital. So there's some opportunities that came up, and moved to DLA and here in the Bay Area, and it's been great. Been working with Paul since I got here on lots of cool deals, and Paul didn't really talk about it, but I think some of the cool stuff that we get our hands on are transactions that are very, very much in the news and really important. Paul led on a deal where he sold the Dodgers, and he was one of the lead lawyers, so that was cool. And we worked on a bid for Forbes magazine earlier this year, and so cool stuff that comes up in the Wall Street Journal, where even TechCrunch or VentureBeat and so forth and so on. So buying and selling companies is fun. I'd say it's kind of like a team sport, and that's what I like about it. There's a lot of moving parts, specialists. We have privacy experts, employee benefits, intellectual property experts, and the corporate team generally kind of quarterbacks the deal process, and it's a fun process. And I think as you win smaller negotiations, you can kind of feel a sense of accomplishment, and when you close a transaction, it's really fulfilling in a lot of ways. I think one of the things that Dean Stanley asked me to talk about was the bridge between law classes and actual practice, and it's interesting that she said that. I would say there's 3 particular classes that kind of made my mind, like I think my basic corporate law class, which oftentimes I think is referred to business associations, kind of gave me a background understanding how a company works, like board of directors, officers, basic, structural understandings and fiduciary duties of the officers and directors of companies. And then I took a basic securities regulation class, and I think that's kind of where I started thinking, oh, okay, this is some pretty interesting stuff. Very, very convoluted and boring if you just read the book, but if you put it into a big picture, it can be interesting. Can be is the key word, but not always. And then I took an M&A class, and I really liked my M&A class, and I think that's what kind of inspired me to prod, Paul and I to kind of do this project where we're going to be teaching this class, is because in that M&A class I really got to see kind of like a transaction from a practical perspective. So I took 2 M&A classes. Well, the first one was more of like just really focusing on like cases, case law, mostly like hostile takeovers and a lot of the black letter law. And I took this class where it was, basically running a small transaction. And I think, Paul and I have talked in depth a lot about what we want to do and how we want to make this a practical class, and maybe even pretend, to a certain extent that you're coming in as a first-year associate, like Jamil, who's worked with, I think we've closed like 4 deals in January and February together, and understanding the different roles that people have and actually putting that into play, and on a very simple level. And I think that's one of the things that we've really talked about, and we hope that, we can accomplish. I think in terms of, some applicability in terms of the law, I think once I learned corporate law, I realized, and then I got to the firm and I was like, wow, I don't know anything. And I think one of the questions I had, Jamil and other, younger associates have had was, what does the firm expect me to know when I come in? And we don't expect you to know anything. It's nice if you do, and we are grateful for the law schools like this law school who try to emphasize practicality, but we expect there's going to be a lot of on-the-job learning and providing tools. But I think one of the greatest things, and one of the things I've noticed that Jamil's done really a tremendous job about, is being hungry, and being hungry to learn, and being hungry to figure things out, to the best of your ability, and then being also wise enough to be able to ask questions when you don't know something, and understanding the hierarchy of who to ask questions to. Jamil doesn't go ask Paul questions that I definitely could answer, because Paul's time's worth a lot more money than my time. So, we see things a lot in the billable hour, and I think you can kind of put those metrics in your mind in terms of how you might approach people, and I think you'll find that associates that are more senior than you, Yang, who's from our firm as well, can really be a valuable resource as you go into a firm. So I think
Great, thank you.
stop there.
Any questions? Happy to entertain those now. I'm told them that I have some questions, but let's open it up now to any questions that you all may have. Yes, Mr. Chris.
This is for Tony at the end. Do you have plans to get involved in any of the legislation pending on e-discovery, or how is your firm possibly involved in that?
My firm has stayed out of the fray. We did not write a letter commenting on the proposed amendments. The earliest those might go through are December 2015, and the comment period just closed in mid-February. I've read some great letters from other prestigious firms, and a gentleman who teaches the same course that I do and who's very, very well known in the e-discovery world has written a 30-page paper that takes a look at it from both sides, the plaintiff's bar and the defense bar. But we've mostly stayed out of the fray. If we were to have put in a letter, I feel comfortable enough saying that it would have supported the new version of Rule 37, and I won't get into necessarily what that is, but it might have asked even for a stricter interpretation on what amounts to the spoliation of evidence, and I've seen those comments, but I think that the defense bar should be mostly satisfied. I don't think anyone's exactly thrilled with that drafting of the rule, but it's like a good negotiation in litigation, right? Nobody's perfectly happy. Effectively, I don't think it's going to make things too much different, primarily because the judges are in the practice of doing what's right for each individual case, right? If there's missing evidence, if things have been deleted, the judges are going to look at this on a case-by-case basis and do what's appropriate for this case, and the way the new rules are written, I don't think you're going to change that all that much.
My question was for Paul. You mentioned that your firm was currently working a lot on more private transactions. Are those still cross-border agent transactions, or to what percentage of your practice is now public transactions and versus like private investment? In which way does it go across the pond, if you know what I mean?
Well, I mean, private transactions can be, cross-border or completely domestic U.S. So to answer your first question, what's the proportion of, U.S. versus cross-border? For our firm, we're probably, I think we are the largest law firm in the world. So we do a lot of cross-border transactions, probably a greater proportion than any other law firm out there. I think Baker McKenzie probably does a lot in Jones Day as well. So, as a firm as a whole, it's probably here in the U.S., probably 30%, 40%, or has some cross-border nature to it. And they could be U.S. transactions, but a lot of these technology companies in San Francisco Bay Area now have operations all over the world. So when you look at a company here and everything from due diligence, when you're kind of looking at the various subsidiaries of a target company, you actually have to then go to your office in, let's say, Thailand or Hong Kong, or I did a deal in Portugal last year. So you do have exposure to that cross-border nature. But a lot of times you have U.S. to U.S. and I would say, at least for my practice, that's maybe 50%. It depends, because the deal about M&A is that it's actually really volatile because it's deal by deal. You don't necessarily have clients who are always doing deals, although I think we're lucky to have a couple of those who are serial acquirers. But so you really kind of go to deal to deal. One year could be 80% cross-border, another year could be 80% pure U.S. domestic. Most of the public deals these days are still U.S. to U.S., although a lot of foreign companies are looking into buying public companies and then having to comply with the SEC rules and stock exchange rules. So those end up being fairly complicated because many times those foreign companies don't know what they're doing, and it just takes a longer time to kind of walk them through.
Mr. Barnes, you touched on this, but I want to open it up to everybody else. Can you speak to the practice of hiring contract attorneys and how that's going to affect or compete with us coming out of law school?
Compete with you? How do you mean?
Well, for getting jobs. Clearly, they're not taking up a full-time job, but they're taking away a lot of responsibility that a first-year associate would have.
I think market forces are what they are, and there's not much that can be done necessarily. The way billing is structured at firms that have large data review obligations for clients, and you just don't commonly see a firm saying, well, we'll bill this document review work at this lower rate in order to compete with contract attorneys. And nowadays, clients are paying contract attorney agencies a pass-through rate. So typically, a contract attorney would make $35 an hour. The client will be paying the contract attorney agency directly $55 an hour or $53 an hour. So there's that markup per hour. But to have that work done by law firm associates such that there would be more law firm associates hired to handle that, that's 10 years ago. And unfortunately, I just don't see it changing. One thing that might change it a little bit is predictive coding technology, in a way that the idea behind that is that someday soon, through machine learning and algorithms, text analysis algorithms, you won't need to review as many documents as you're reviewing today, because the ones that the computer tells you just have no relevancy based on the work product you've put into the database over here, don't need to be reviewed, and you statistically sample those to the point where, mathematically speaking anyway, you're pretty positive that this is just a pile of junk with a really low prevalence rate, which means really low relevancy rate versus non-relevance. So, that may curtail a little bit of the amount of contract attorneys needed on each case, but the contract attorney industry itself is not going away. I do think it has an effect on how many lawyers are hired, but I think that effect is primarily within sort of the big law, corporate defense arena, not only, but heavily weighted towards that area of law, that area of litigation. Did that answer your question?
Yeah.
Yes?
Yeah, my question is towards Spencer as a young attorney. What are some tips you have just getting into your practice in terms of efficiency, things that you do? Because I know that, like Jamil being a first-year associate, there's a lot of things coming at you. What are some things you do to keep that organized and to keep it on point to help you stay focused?
Yeah, I think that draws me back to the hierarchy mention. I think when you come in as a first year, you should understand who is my client, because a lot of times your client isn't actually the client of the firm. Your client is the associate who's managing your workload, right? So whether that be me, we're young, who's helping manage Jamil, where in Paul's case, he's my client because I'm trying to make Paul. I think the general feeling should be, what can I do to the best of my ability to make the guys and girls above me look better? And I think if you come in with that mentality and that kind of, I'd say the biggest thing that, since I'm on the hiring committee, when we look at candidates and we try to evaluate, how they're going to do, we look for a couple things. I think we want to see that they're hungry to work hard and to be diligent. And of course, we generally don't interview people, that unless we think they're of a certain intelligence and smart. But that doesn't mean always that it's reflected in good grades. You can be smart in other ways. I think that they have good work ethic, and really, I think one of the key things is attention to detail, because as a younger associate, you're expected not to make mistakes in things that you have within your control, right? Spelling the CEO's name right, giving him the right title, right? If you have a piece of paper that tells you who the directors of the company are and you're drafting, board resolution, all their names should be there and the date should be right and stuff. Things that are within your control, you should do to the best of your ability perfectly, right? Because then I think what happens is you're always trying to build trust. This is always about trust, because the more trust you have, the more substantive work that I think partners or senior associates are more willing to give you. So,
and let me just reinforce that too. I mean, from my perspective, I think the commitment to doing things right and going the extra distance really is impressive. And the way the law industry works, because I think Spencer has actually figured it out in a lot of ways, the business of law. And so, really, it is a client-based business. That's what drives our business. And your client can be, a real live client, or it can be people within the firm. But you're constantly networking. You're constantly trying to figure out, who's my client and how do I serve that client better? And that really does require some real strategic thinking on your part. It requires attention to detail, like Spencer said, because there can't be any mistakes. I mean, there's been many careers destroyed because people made stupid mistakes, and you just can't make those mistakes. I mean, that's just sort of the reality.
but everyone does make mistakes.
Right.
No one's perfect.
Right, and partners make mistakes too, obviously. But I think at the beginning stage, you just want to be more careful as a first-year associate. In any place. I mean, it doesn't matter, if you're a contract lawyer or you know, you're a first year corporate associate, litigation associate, or in compliance or whatever. You know, it's really, you know, just focusing on doing a really great job and looking at solutions. At least for corporate M&A, you know, what we look for in an associate is someone who's looking for solutions, as opposed to just, okay, you know, this section, blank, or whatever, you know, has an issue. I mean, before you even go to a partner or a senior lawyer or, you know, even your colleague, say, yeah, there's an issue here, but this is how I'm going to resolve it. This is my proposal. And then that goes a longer way than just like, here's an issue, here's a list of issues. Because, you know, when we do an issues list for an M&A transaction, we don't just list out the issues. We actually say, you know, here are some options in which, you know, you as a client can consider to solve this issue.
Great, I'm just going to wrap up, and then I want some time for you to be able to talk with them independently afterwards. One of the things I wanted to let you know is that we've got some really exciting new courses in our business law curriculum that will be starting next year and continuing next year. Obviously, Professor Glazer's privacy law course, extraordinary course. Amy's corporate compliance course, that was a brand new course. Tony's e-discovery course, brand new course this spring. And the M&A course has been on our schedule, but we haven't been able to teach it for a couple of years. So very excited to have both Paul and Spencer this fall to teach that course. In addition, there's a great course on venture capital, starting up a technology company. Fantastic course taught by David Giorgiello, who's amazing. And that'll be in the fall. In the spring, we're starting a brand new course I'm very excited about. It's called International Business Negotiation. And the whole course is a negotiation, and we will be paired with another law school to negotiate against. And the problem has to do with one side is a pharmaceutical company, and the other side is a third world country with a natural resource the pharmaceutical company wants to acquire. So as it looks now, we're going to be negotiating with the University of Denver Law School. So a lot of that's going to be done over the airways, so to speak, but the class will negotiate different pieces of the deal for the pharmaceutical company to acquire the natural resource to develop a new drug. So that's like real-time, real negotiation in a very modern context, a modern setting. And Professor Giorgiello and one of Paul and Spencer's partners, Craig Tigey, will be teaching that class, and that'll be in the spring. So lots of great things going on in terms of opportunities for you to learn. You can go onto the GGU website, click under course offerings, and then business and commercial law. There's a whole list of them. I'll make one more pitch, two more pitches. One for if you want to do this kind of work, but you don't have an accounting or finance background, take accounting for lawyers. You'll learn how to read a balance sheet and financial statements, be able to speak the language of business. And the other language of business is taxation, so take federal income tax, corporate tax if you're so inclined, very sort of basic entry-level foundation knowledge about those two things that may get you over an intimidation factor. If you're interested in this kind of work, but feel like you may not have, maybe you were a philosophy major, college or something, you don't have that kind of background, we have that education here for you, and these doors will be open to you. So why don't we conclude at this point.